Imagine a nation built on this really delicate balance, right? Individual freedoms, the collective good, and the power to truly transform society. How does a constitution even manage such huge aspirations, especially in a place like India, so vast, so diverse? Today, we're embarking on a deep dive into some of India's, well, most fascinating constitutional provisions, the ones that really define this balance. We want to reveal that intricate legal architecture underpinning its democracy. Our mission today is pretty clear. We want to explore how the Indian Constitution meticulously protects cultural identity and educational choices, how it enables these sweeping socioeconomic reforms that have, reshaped millions of lives, and maybe most importantly, how it provides that ultimate, almost unassailable safeguard for every single citizen's fundamental rights. We'll be meticulously examining Articles 29, 30, 31A, 31B, 31C, and what Dr. B.R. Ambedkar famously called the heart and soul of the Constitution, Article 32. It's really a journey through some of the most dynamic and frankly debated aspects of Indian law.
Yes, and what's truly fascinating here, I think, is how these articles, some woven right into the original fabric, others added pretty early on through amendments. They really reflect this ongoing conversation. It's often quite spirited, a conversation between individual liberties and the broader, often very ambitious goals of a developing, incredibly diverse nation. We'll try and connect these intricate dots for you, reveal not just the what of these legal frameworks, but the compelling why behind how they came about and how they've evolved. It's a story of constitutional pragmatism, but also ideological commitment.
Right. So settle in for some hopefully profound aha moments as we unpack these really powerful legal tools. Tools that don't just shape modern India, but actually offer profound insights into constitutional governance everywhere. This isn't just about dry law, is it?
Not at all.
It's an exploration of the very fabric of society, the tensions it holds, the aspirations it embodies. You're about to discover how these maybe dry-looking articles actually animate a living, breathing democracy.
Yeah.
Okay, let's begin our journey by looking at something utterly foundational to India's identity. That's the protection of cultural and educational rights. We're talking Articles 29 and 30. These provisions aren't just legal statutes. They feel more like vital expressions of India's commitment to fostering a truly pluralistic ethos.
Exactly. They aren't just rights on paper, they're really acknowledgments of India's very DNA, its diversity. So, Article 29, think of it as a constitutional guardian. It protects the distinct identity markers of, well, any section of citizens. Could be their language, script, or culture. It has this dual purpose: protect that unique identity and ensure non-discrimination in state-linked education. What's truly fascinating and often missed is that while many people immediately think minority rights when they hear Article 29,
Yeah, that's a common association.
right, but the language the framers use is deliberately broader than you might think. It actually casts a much wider net.
Okay, let's really unpack this because that distinction sounds critical.
Yeah.
Clause 1 states, and I'm quoting here, any section of the citizens residing in the territory of India, having a distinct language, script, or culture of its own, shall have the right to conserve the same. So, any section, does that really mean it's not exclusively for groups we typically label minorities? Could it apply, say, to a majority community if they have a distinct cultural aspect they want to preserve?
Yeah.
Like a specific dialect or tradition?
Precisely. You've absolutely hit on a critical nuance. The Supreme Court has made this very clear. This right isn't narrowly confined. It extends to any identifiable section of citizens. So hypothetically, yes, it could even include segments of the majority community if they possess and want to preserve something distinct, maybe a unique regional dialect, like you said, or a specific folk tradition. And the right to conserve itself is also deeply significant. It implies much more than just passively preserving something.
Right. It sounds active.
It is. It actively includes the right to promote and propagate that language, script, or culture. And crucially, this naturally extends to establishing educational institutions specifically designed to teach and foster one's language or cultural heritage. This gives groups tangible, practical ways to maintain that identity, to pass it down through generations.
Okay, so let's make this concrete. If you have a linguistic minority group, say the Santali-speaking community, in a state where Bengali is dominant,
Right.
and they want to open schools where Santali is the main language of instruction, or where their unique traditions, like their script, Old Chiki, are taught and celebrated, Article 29(1) gives them the constitutional backing for that.
It absolutely does. That's a perfect example. It's an incredibly powerful tool for ensuring cultural continuity and vibrancy.
And has this been tested in courts?
Oh, yes. This principle has been robustly affirmed. There's a landmark case, State of Bombay versus Bombay Education Society, back in 1954. It was pivotal. It established that this right definitely includes the ability to impart education in the language a group wants to conserve. The state can't just impose restrictions that effectively destroy this right.
Okay.
And then conversely, you have the DAV College Julender versus State of Punjab case from 1971. This showed the flip side. Punjab had mandated Punjabi instruction in the Gurmukhi script for all colleges affiliated with a specific university.
Right.
But for groups like the Arya Samajis, whose cultural identity was deeply tied to Hindi and the Devanagari script, this wasn't just a curriculum change. It felt like an existential threat to their distinct identity.
Ah, I see.
The court had to step in. It ruled that while a state can certainly promote its language, it cannot compel a section of citizens to adopt it if that undermines their fundamental right under 29 to conserve their own language and script. It really highlights that delicate balancing act.
Fascinating balance. Okay, following on from that conservation right in Clause 1, we have Clause 2. This one mandates, no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language, or any of them.
Oh.
What does this mean for the individual student? How does it stop discrimination in public education?
This clause is very specific. It's a direct right for individual citizens. It protects them against discrimination in educational institutions that are either run by the state or receive state funding. The beauty is its precision. The prohibited grounds are crystal clear. Religion, race, caste, and language. Only those.
Only those grounds.
Which raises a crucial question, one that comes up all the time in practice. If a student is denied admission for other reasons, say they didn't meet the academic cutoff, or maybe the college is simply full, does that count as a violation of Article 29 too?
My guess is no, because of that very specific wording. On grounds only of those things. So if you're not academically qualified or there are no seats left, that's unfortunate, but it's not a violation under this article.
Exactly.
But if the sole reason for denying admission is, say, their religion or the language they speak at home, then it's a clear breach.
You've articulated the key principle perfectly. A student denied admission to a government-aided engineering college because their entrance exam scores are too low. No claim under 29. But if that denial was solely because of their religion or caste, that's a clear, undeniable violation. And this clause has a powerful history, too. The State of Madras versus Amantat Champakam Dora Rajan case in 1951 was a real watershed moment.
Ah, yes, the Champakam case.
The court, enforcing Article 29, struck down a government order that had essentially set quotas for college admissions based on caste and religion, which was intended as a form of affirmative action at the time. That landmark ruling directly led to the First Amendment, which introduced Article 15.4. This explicitly empowered the state to make special provisions for the advancement of socially and educationally backward classes.
So the Constitution adapted quickly.
Very quickly. It's a vivid example of how the Constitution had to adapt to address these competing demands, individual non-discrimination versus the state's need for collective social justice.
So just to summarize this bit then, Clause 1 is this broader communal right for any section to conserve its identity markers, even setting up institutions. While Clause 2 is a very specific individual right against discrimination in state-supported education. How do these two, working together, contribute to that grander vision of India's cultural pluralism?
Well, if we connect this to the bigger picture, Article 29, really in its entirety, reflects India's foundational commitment to preserving its incredibly rich kaleidoscopic diversity. It acts like a constitutional shield. It ensures that the countless cultural groups within India can not only maintain their unique identities, language, script, culture, but also actively foster them. And this is absolutely essential, for cultivating a deep sense of belonging and meaningful participation for everyone in a pluralistic society like India's. It actively pushes back against forced assimilation and instead supports that vibrant, evolving mosaic that defines the country.
Okay, so Article 29 gives this broad protective cover for cultural conservation. But what if a minority community wants to do more? Not just conserve, but actively shape their future, educate their kids according to their own ethos, really flourish in their distinct identity. That, I guess, is where Article 30 comes in. It sounds like it provides a much more proactive, maybe more powerful set of rights specifically for minorities. What's the core idea?
You've articulated that perfectly. Article 30 grants religious and linguistic minorities a truly fundamental and, yes, deeply empowering right. the right to establish and administer educational institutions of their choice. This isn't just a general right, it's a crucial, specific entitlement. It's designed explicitly to enable minorities to preserve their distinct identity, culture, and language, and importantly, to ensure their educational advancement on their own terms. It's very much a proactive right for specific groups.
That difference is key.
Hmm.
Clause 1 states, all minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Let's dig into the specifics here. How is minority usually defined in the Indian context? The Constitution doesn't spell it out right.
That's right. Interestingly, the Constitution itself doesn't offer a precise definition. This has led to quite a bit of judicial interpretation over the years. Generally, for linguistic minorities, status is determined state by state, relative to the state's population. For religious minorities, it's often assessed at the national level, although for specific state laws, the state population can become relevant too.
Okay. And what about administer? What does that actually entail? It sounds significant.
Oh, it is hugely significant. The right to establish is fairly straightforward. It means to create or found institutions. But administer is where the real power lies. It implies a substantial degree of autonomy to manage and conduct the institution's affairs. This covers fundamental decisions: choosing their own governing bodies, appointing staff teachers, administrators, everyone admitting students according to their own criteria, and determining the medium of instruction.
Wow, that's quite broad.
And the phrase "of their choice" is also expansive. It means minorities aren't restricted to setting up just, say, religious seminaries or language schools. They can establish general education schools, professional colleges like engineering or medicine, vocational training centers, all while maintaining their distinct minority character and ethos.
This is where it gets really interesting for me. So take a linguistic minority, maybe the Sindhi community, in a state.
Okay.
They could set up a school, teach in Sindhi perhaps, or maybe English, but with a focus on Sindhi culture, recruit teachers who are qualified but also align with their community's values, offer a standard curriculum. And they can do all this while seeking state recognition as long as they meet general standards.
Exactly. That autonomy is the very essence of the right, under Article 31. It ensures the distinct character and ethos of their institution are maintained. It allows them to provide education that really resonates with their community's specific needs and cultural aspirations, rather than being forced into a purely majority-driven educational mold. That freedom is key to security and belonging.
Beyond that core right, there's Clause 1A about property acquisition and Clause 2 about state aid. How do these strengthen the right further?
Right. Clause 1A, which was added by the 44th Amendment in 1978, interestingly, after the property right was shifted, acts as a critical safeguard. It basically says if the state compulsorily acquires the property of a minority educational institution, the compensation must be adequate. It shouldn't restrict or basically destroy their right to establish and run such institutions.
So it prevents the state undermining the right indirectly.
Precisely. It stops the state from offering just nominal compensation, making it impossible for the institution to continue or rebuild. Clause 2 then focuses on financial equality. It explicitly prohibits the state from discriminating against minority-managed institutions when giving out financial aid, provided they meet the general secular quality-based criteria.
So equal opportunity for funding.
Yes, they can't be denied aid just because they're run by a minority. It reinforces the idea that their distinct character shouldn't be a disadvantage in accessing state resources.
Given all this autonomy, this right to administer under 31, is it absolute? Or can the state still impose regulations?
That's a very sharp point, and exactly where the Supreme Court has had to draw some careful lines over the years. While Article 31 isn't explicitly subject to the reasonable restrictions you see in Article 19, the courts have consistently said it's not an absolute right. The state absolutely can, and frankly should, impose reasonable regulations. These might be about ensuring academic excellence, maintaining discipline, upholding public health standards, setting minimum teacher qualifications, things like that.
There's a limit.
There's a crucial limit. These regulations cannot be so intrusive or overbearing that they effectively destroy the minority character of the institution or take away its administrative control. This inevitably raises that tough question: where exactly do you draw the line between legitimate regulation and unconstitutional interference?
For instance?
Well, for instance, prescribing minimum qualifications for teachers is generally seen as, okay, it ensures quality. but maybe dictating the exact composition of their governing body or forcing them to admit non-minority students beyond a certain point might cross the line into infringement. It's a constant balancing act.
It sounds like a fascinating tightrope walk. So if we look back at 29 and compare it directly to 31, what's the key difference? They seem related, but definitely distinct.
Yeah, the key difference is really in their scope and specificity. Article 29 is broader in who it applies to any section of citizens, and it grants the right to conserve culture, language, script. Now, that right can certainly be exercised by setting up institutions, but Article 31 is highly specific. It's granted only to minorities, religious and linguistic, and it explicitly grants that much more potent, proactive right to establish and administer institutions of their choice. That implies a greater degree of autonomy over management.
So 31 is a stronger, more focused tool for minorities.
Exactly. While both aim to protect identity, 31 provides a dedicated, arguably stronger tool for minorities to achieve that through institutional education. And, this article has been central to numerous landmark court cases shaping how it's applied. The Inri Kerala Education Bill case in 1958 was foundational. It established the wide scope of the right, but also allowed for reasonable regulation for efficiency and discipline. Then you had the Mother Provincial case in 1970. The court struck down rules that interfered too much with how minority colleges were run, like dictating governing body makeup. Said it destroyed the right's essence. And St. Xavier's College Society versus State of Gujarat in 1974, a big 9-judge bench, powerfully reaffirmed that the right to administer includes choosing the medium of instruction. These cases really carved out the boundaries.
And then came the really big ones, right? The cases that significantly reshaped the whole educational landscape. TMA Pay Foundation in 2002 and PA and Amdar in 2005. How did they really impact Article 30?
Absolutely, those were monumental. TMA Pay Foundation, an 11-judge bench decision, clarified so much. It affirmed the right of minority institutions to admit students of their choice, set reasonable fees, appoint their own staff, take disciplinary action, all subject, of course, to maintaining academic standards. Critically, it also stressed greater autonomy for unaided minority institutions compared to aided ones, where the state naturally has more regulatory leverage because it's providing funds.
And PA and Amdar.
PA and Andar in 2005 elaborated further. It clarified that the state could not impose reservation quotas for seats in unaided private institutions, whether minority or non-minority. That was a strong assertion of their autonomy in admissions. These cases really kicked off a major phase of balancing minority rights with state affirmative action policies and the public interest in quality education. It's a tension that was further refined in Pramati Educational and Cultural Trust in 2014, which clarified that Article 15, allowing reservations, can apply to minority-aided institutions, but explicitly excludes unaided ones from mandatory quotas.
It's a constantly evolving dialogue then.
Absolutely. It shows the dynamic nature of constitutional interpretation in action.
So, zooming out again, what does this complex web of rights and court decisions mean for fostering a truly diverse, inclusive nation like India? What's the ultimate takeaway for us, the citizens?
Well, these articles, particularly Article 30, are absolutely vital. They instill a profound sense of security and belonging among minorities. They empower them not just to preserve their distinct identities, but also to contribute meaningfully and autonomously to the national educational landscape. It's not just about protection. It's about actively fostering choice, enabling self-determination in education. It ensures India's rich cultural tapestry isn't just conserved like a museum piece, but actually thrives, evolves, and flourishes through dynamic community-led initiatives. It's really a constitutional declaration that diversity is a strength to be nurtured.
Okay, before we dive into Articles 31A, 31B, and 31C, we really need to quickly touch upon the original Article 31. That was the right to property, initially a fundamental right, but it was eventually repealed as a fundamental right in 1978, moved to Article 300A as just a constitutional right. Why is this history, this whole evolution of property rights, so absolutely crucial for understanding these saving clauses?
That's not just crucial, it's really the entire backstory, the very reason these saving clauses exist. You see, India, after independence, inherited a deeply, deeply unequal society, especially regarding land ownership. The zamindari system, this sort of feudal-era land tenure system, had concentrated vast amounts of land and economic power in the hands of a very small elite.
Leaving most cultivators in poverty.
Exactly, widespread poverty, exploitation. So the new democratic state, guided by its directive principles, which urged equitable distribution of resources, preventing wealth concentration, had this urgent, massive mandate for sweeping socioeconomic reforms, especially agrarian reforms like abolishing zamindari.
But Article 31 stood in the way.
It became an immediate, formidable legal hurdle. Landowners, often these powerful zamindars, routinely challenged the new land reform laws in court. They argued these laws violated their fundamental rights to property under Article 31, to equality under Article 14, sometimes even freedom to carry on business under Article 19.
Mhm.
And the judiciary, particularly in the early days, sometimes sided with these property rights arguments. This created a profound constitutional dilemma.
How could the state push reforms?
Exactly. How could a welfare state committed to social justice push through essential reforms if they were constantly being stalled or struck down based on fundamental rights claims? It escalated into this virtual tug of war between Parliament's legislative will, its reform agenda, and the judiciary's role as the protector of fundamental rights.
A real clash.
A real clash.
Yeah.
And it was in direct response to this very real, almost existential challenge to India's reform agenda that Articles 31A, 31B, and 31C were introduced, starting with the very first amendment in 1951. They're called saving clauses precisely because they were designed to save certain reform laws from being struck down, effectively providing a constitutional shield against these fundamental rights challenges.
So Article 31A, brought in by that First Amendment in 1951, was a direct answer to this property rights dilemma. Its main job was protecting certain laws from challenges under Article 14 equality and 19 freedoms. But what specific types of laws were the framers trying to shield here? What was the practical focus?
Well, its core purpose was nothing less than enabling a massive restructuring of India's agrarian and economic landscape. A huge task. It did this by creating a sort of constitutional safe harbor. It immunized 5 very specific categories of laws from challenges based on Article 14 and Article 19. This was a deliberate, powerful carving out of exceptions. It signaled that for certain critical socioeconomic goals deemed essential for national progress, these particular individual rights would have to take a back seat.
Prioritizing the collective good in specific areas.
Exactly, prioritizing the collective good over certain individual entitlements, but only in these very specific, circumscribed contexts defined by the article.
Okay, that makes sense. What are these 5 protected categories, and how did they directly tackle the reform agenda of the new nation?
Right. The first, and arguably the most pivotal category, concerns the acquisition by the state of any estate or rights within it. This was the direct legal weapon for abolishing the zamindari system and other intermediary land tenures. Absolutely crucial for land redistribution to the actual tillers. And the definition of estate itself was made incredibly broad. It covered various land tenure systems across India, jagars, inams, Rewetwari settlements, even just lands used for agriculture or related purposes. This ensured it had a comprehensive reach.
So primarily land reform. What else?
Beyond land reform, the article also protects laws allowing the temporary taking over of management of any property could be an undertaking, an industry, even an educational institution if it's in the public interest or needed for its proper management. This tackled issues of gross mismanagement harming society. The third category covers the amalgamation of corporations, again, if it's in the public interest, maybe to streamline economic activity or prevent monopolies. Fourth is about extinguishing or modifying the rights of corporate directors, managing agents, or shareholders, essentially allowing the state to reform corporate governance structures. And finally, number 5, protects laws dealing with the extinguishment or modification of mining leases or licenses. Together, these 5 categories gave the state immense power to restructure foundational economic arrangements to serve broader societal goals, hopefully without getting endlessly tied up in court.
Okay, here's where it gets really illuminating for me. So let's say a state government passes a law to abolish zamindaris and redistribute that land to the farmers actually working it.
Right, the core reform.
That law, once it gets the president's okay, effectively cannot be challenged in court for violating the former zamindars' fundamental right to equality under Article 14 or their freedom to manage their estates under Article 19. Is that right?
That's exactly right. This immunity was absolutely crucial for those initial massive waves of land reform that fundamentally changed rural India. Without 31A, the entire land reform agenda, a cornerstone of India's early development policy, would have been perpetually bogged down in legal challenges from powerful landed interests. It just wouldn't have happened at the scale it did.
And the other categories too, like managing companies.
Yes. Similarly, if a major company was being grossly mismanaged, maybe threatening public harm or economic stability, the government could potentially invoke a law protected under 31A to take over its management for a limited period. That action would then be shielded from challenges based on the management's Article 19 rights to carry on their business. The idea was to prioritize the larger public good in such critical situations.
This sounds like an incredibly powerful tool for the state. But surely it wasn't a completely blank check. Were there safeguards? Protections for smaller players?
You're right, it wasn't a blank check, and safeguards were indeed added, showing that ongoing constitutional learning curve. Firstly, state laws needing 31A protection require presidential assent.
A central check.
Yes, a crucial check by the union executive, ensuring some national alignment and oversight. More importantly, a second proviso was added by the 17th Amendment in 1964. This safeguard ensures that if the state acquires land that is under someone's personal cultivation, and that land falls within the statutory ceiling limit, meaning it's the personal holding of a smaller landholder, not a vast estate,
Right.
then the state must pay compensation at not less than the market value. This was a significant protection for smaller, more vulnerable landholders, trying to balance the big reforms with individual fairness.
And courts can still look at it.
Absolutely. Courts can still examine whether a law genuinely falls within one of the 5 categories listed in 31A. The legislature can't just label any law as falling under 31A. There has to be a real connection. Furthermore, the Supreme Court in the Monroe case in 1981 clarified something very important. Any amendments made to Article 31A after April 24, 1973, the date of the Kesavananda Bharati judgment, could potentially be challenged if they damage the Constitution's basic structure.
Ah, the basic structure doctrine again.
Exactly. It established a critical, overarching limit on legislative power, even when dealing with these saving clauses.
So if considering all these layers, the power, the exceptions, the safeguards, the judicial review, what does Article 31A ultimately tell us about the Indian Constitution's approach to balancing rights and state goals, especially back then?
Well, Article 31A stands as this powerful testament to the Indian Constitution's pragmatic and deeply reform-oriented spirit. It represents a deliberate constitutional choice. A choice to prioritize certain pressing socioeconomic goals, many drawn directly from the directive principles over individual property rights and certain freedoms, but only in specific, well-defined contexts. It enabled those monumental post-independence reforms, especially in the agrarian sector, that were just absolutely essential for building a more equitable society. It's a vivid illustration of how a constitution can be designed to be both a guardian of liberty and a facilitator of profound social change.
Okay, moving on, we come to Article 31B, also brought in by that same crucial First Amendment, and it's intimately linked with something called the Ninth Schedule. What's the core function of 31B, and how does it connect to this, well, slightly mysterious Ninth Schedule?
Article 31B is essentially a constitutional protective umbrella. Its core function is to immunize any law listed within this special list, the Ninth Schedule, from challenge in court on the ground that it violates any of the fundamental rights in Part 3 of the Constitution.
Any fundamental right, not just 14 and 19 like 31A.
Exactly. Any of them. Think of it as a constitutional vault. What makes it exceptionally powerful is that broad scope protection against all fundamental rights challenges, and furthermore, it operates retrospectively. It explicitly states that such laws put in the schedule shall not be deemed void, notwithstanding any judgment, decree, or order of any court or tribunal to the contrary. It was basically trying to override past court rulings that might have struck down similar laws.
Wow, that sounds incredibly powerful, almost absolute immunity. So if Parliament just decides to stick a law into the Ninth Schedule, is it then completely untouchable? Even if it seems to blatantly violate fundamental rights, that could theoretically give Parliament immense, maybe unchecked power, couldn't it?
You've put your finger on the precise concern, the very issue that eventually led to a seismic shift in how the courts viewed this. For decades, yes, laws placed in the Ninth Schedule were indeed considered almost absolutely immune. The initial intention was primarily to shield crucial land reforms and other socioeconomic laws from endless legal challenges.
To clear the path for reform.
To clear the path, however, the question inevitably arose. Could Parliament just use the Ninth Schedule as a kind of legislative loophole? Could they put any law into it on any subject and thereby simply bypass all fundamental rights and, crucially, judicial review? This critical question was finally and decisively addressed by the Supreme Court in the landmark I.R. Coelho case in 2007. This was a real turning point.
What did Coelho decide?
The I.R. Coelho judgment established a crucial limitation. It held that while Article 31B in the Ninth Schedule do provide immunity, any law included in the Ninth Schedule after April 24, 1973.
The Kesavananda Bharati date again.
That exact date. Any law added after that date is open to challenge if it violates the basic structure of the Constitution. This includes fundamental rights that are considered part of that basic structure, like Article 14, equality, Article 19, freedoms, or Article 21, life and liberty. So it wasn't absolute immunity after all. This was a monumental reassertion of the power of judicial review. It limited Parliament's ability to create this completely immune zone. It
Yeah.
was the judiciary effectively saying, you can legislate, you can even amend the Constitution, but you cannot destroy its foundational pillars.
Okay, let me see if I've got this straight. So if a radical land sealing law was enacted and put into the Ninth Schedule, say back in 1960, before April 1973,
Yeah.
it would have enjoyed near absolute protection from fundamental rights challenges.
Largely, yes, based on the understanding at the time.
But if an identical law were to be added to the Ninth Schedule today after that 1973 day, it would now be subject to judicial scrutiny. The court could examine if it violates the basic structure of the Constitution, which might include looking at its impact on fundamental rights like equality or property, though property is now just a legal right. That's a profound difference.
Exactly. It's a fascinating and absolutely essential evolution in constitutional law. It demonstrates how judicial interpretation dynamically shaped and ultimately limited the scope of parliamentary power. Early cases like Shankari Prasad and Sajjan Singh had initially upheld the broad validity of the Ninth Schedule amendment process. But it was Kesavananda Bharati establishing the basic structure doctrine and then Waman Rao applying it prospectively that really set the intellectual stage for I.R. Coelho to define the Ninth Schedule's ultimate nuanced boundaries. It ensures that even constitutional amendments themselves must adhere to the core principles defining India as a democratic republic. This whole constitutional drama really shows the concept of a living, evolving document in action.
All right, now we arrive at Article 31C. This one seems to have perhaps the most dramatic and controversial history of all these saving clauses, deeply tangled up with major constitutional battles. It was introduced, I believe, to give primacy to certain directive principles over fundamental rights. What was its initial, quite ambitious aim?
Yes, Article 31C, inserted in 1971 by the 25th Amendment. This was during a period of intense political and economic upheaval. Remember, Mrs. Gandhi's Garibi Hatao slogan was a very bold legislative move. Its initial aim was indeed to shield laws enacted to implement specific directive principles, originally just Article 39B and C.
What are those about again?
Article 39B talks about the distribution of ownership and control of material resources of the community to best serve the common good. And 39C is about ensuring the economic system doesn't result in the concentration of wealth and means of production to the common detriment. So very core socialist egalitarian principles.
Okay, so protect laws implementing those.
Protect them from challenges under Articles 14, equality, and 19, freedoms. It was a significant attempt by Parliament to elevate these specific socioeconomic goals, aimed at reducing economic disparity over what were often seen as potentially obstructive individual fundamental rights, especially property rights, implicit in Article 19. It explicitly sought to resolve that long-standing tension.
And this is precisely where the story gets incredibly complicated, isn't it? Because this article leads us straight into the legendary Kesavananda Bharati case, perhaps the most significant constitutional case in Indian history. What exactly happened there with Article 31C?
Indeed. The Kesavananda Bharati case in 1973 was absolutely pivotal. A true constitutional showdown, 13 judges, the largest bench ever. The court, in that famous narrow 7-6 majority, made two absolutely crucial pronouncements regarding Article 31C. First, it actually upheld the first part of 31C. It confirmed that laws which genuinely gave effect to Article 39B and C could indeed be protected from challenges based on Articles 14 and 19. That was a win for Parliament's power to pursue social justice.
But there was a but.
A huge but. The court struck down the second part of 31C. This part was famously known as the Declaration Clause. It had stated that if the legislature simply declared that a law was for implementing these principles, 39B and C, that declaration could not be questioned in any court.
So basically saying, trust us, this law is for the common good.
Essentially, yes, and the court emphatically rejected that. It held that judicial review, the power of courts to examine the constitutionality of laws, is a basic feature of the Constitution, an irreducible core principle. Parliament could not simply oust judicial review through a mere legislative declaration. The courts retained the power to see if the law actually had a connection, a nexus, to those principles. This was the birth, or at least the definitive statement, of the basic structure doctrine. Truly monumental.
So the judiciary firmly asserted its right to review, even for laws supposedly implementing directive principles. But the saga didn't end there, did it? Because the 42nd Amendment during the emergency then tried to expand 31C even further. To cover all directive principles, that didn't stick either, right? It really was a constitutional tug-of-war.
Precisely. The government, clearly not happy with the Kesavananda ruling limiting 31C, pushed back hard. In 1976, during the emergency, they passed the sweeping 42nd Amendment. Among many other changes, it drastically expanded Article 31C's protection. It tried to shield laws implementing any directive principle, not just 39B and C, from challenges under Articles 14 and 19.
A massive expansion of immunity.
Huge. It was an attempt to give a blanket constitutional shield to potentially any law that could be framed as implementing any directive principle. But this ambitious attempt was firmly struck down just a few years later in the equally significant Minerva Mills case in 1980.
What did Minerva Mills say?
The Supreme Court held that this vastly expanded version of Article 31C destroyed the essential balance, the harmony, between fundamental rights, Part 3, and directive principles, Part 4. The court declared this balance itself to be a fundamental feature, part of the basic structure of the Constitution. You couldn't just elevate one part completely over the other without dismantling the Constitution's core equilibrium. So, as a result of Minerva Mills, Article 31C today effectively protects laws related only to the original Articles 39B and C. The 42nd Amendment's expansion was invalidated.
What a dramatic history. So let's bring it to the present. What does this all mean for us today in contemporary India? What's the current practical scope and significance of Article 31C?
Okay, so today Article 31C remains an active, valid provision, but only in its pre-42nd Amendment form. It protects laws that genuinely implement Article 39B and C from being struck down just because they might violate Article 14 or 19. However, the crucial catch, established firmly by Kesavananda and reaffirmed, is that courts retain the power to examine whether there's a genuine and direct nexus, a real connection between the law and these specific directive principles, 39B and C. A mere declaration by the legislature saying this law is for 39B and C is not enough. The courts will look beneath the surface to see if it truly serves those objectives.
So judicial review remains key.
Absolutely. This represents that complex, enduring constitutional negotiation. It acknowledges the paramount importance of socioeconomic goals, but at the same time safeguards the basic structure of the Constitution and the essential role of judicial review. The court in Sanjeev Coke Manufacturing Co. in 1983 specifically affirmed the correctness of Minerva Mills in limiting 31C's scope, ensuring that balance holds.
So to give an example, if the government wants to nationalize, say, key natural resources to prevent wealth concentration, a law enacted for that purpose could be protected under 31C from challenges under 14 and 19 if it genuinely and demonstrably serves Article 39B or C.
Correct.
But if it's just seen as an arbitrary exercise of power, maybe benefiting certain interests, even with the declaration saying it's for 39BC, the courts can and likely will still step in and examine it.
Precisely. It embodies that vital principle of harmony and balance. It underlines that while the state has a profound and legitimate duty to achieve socioeconomic justice and uplift the disadvantaged, it cannot do so by completely overriding the fundamental rights that form the Constitution's core, nor can it bypass the judiciary's role as the final interpreter of that foundational document. It's a continuous, dynamic process of achieving justice within constitutional bounds.
Okay, we've explored rights for culture, rights for minorities, the state's power to reform, even when it bumps up against rights. But what happens when those fundamental rights, the absolute bedrock of our freedom, are actually threatened or violated? This brings us to an article that Dr. B.R. Ambedkar famously and so powerfully called the very soul of the Constitution and the very heart of it, Article 32. What makes this article so uniquely profound, so indispensable?
Well, what's truly fascinating and utterly foundational about Article 32 is that it is not just another right listed alongside others. It is in itself a fundamental right.
A right to protect rights.
Exactly. It stands as a constitutional guarantee. It ensures every single person an effective, reasonably quick, and constitutionally secured remedy for the enforcement of all other fundamental rights listed in Part 3. It perfectly embodies that timeless legal maxim, ubi jus, ibi remedium, where there is a right, there is a remedy. Think about it. Without Article 32, all those other fundamental rights we cherish, freedom of speech, equality, right to life, they could become little more than, well, noble declarations on paper. They lack real enforceability, practical substance. Article 32 explicitly makes the Supreme Court the protector and guarantor of these most cherished rights. It's the ultimate constitutional safety net.
That's a powerful concept indeed. A fundamental right specifically designed to enforce other fundamental rights. So Clause 1 gives you the guaranteed right to directly move the Supreme Court using appropriate proceedings for their enforcement. And then Clause 2 empowers the Supreme Court to issue directions or orders or writs. What exactly are these writs? How do they function as these constitutional tools you mentioned?
Right. These writs are ancient, very powerful legal instruments, largely inherited from English common law tradition. The Supreme Court is empowered to issue these, along with any other appropriate directions or orders needed, to ensure justice is done when fundamental rights are breached. Think of them as specialized legal tools, each designed to address a specific type of violation or legal wrong, especially concerning fundamental rights. There are 5 traditional types. First, habeas corpus, Latin meaning you may have the body. This is perhaps the most fundamental writ for protecting personal liberty.
The most famous one, Major.
Probably the most famous, yes. It's issued to secure the release of someone who's been unlawfully detained or imprisoned. It essentially commands the detaining authority to bring the detained person before the court so the court can examine the legality of their detention.
Give us an example.
Okay, imagine someone is arrested by the police and they're held illegally beyond the statutory 24-hour limit without being produced before a magistrate. Their family, or even a concerned friend or citizen, can immediately go to the Supreme Court or the High Court under Article 226 and ask for a writ of habeas corpus to challenge that unlawful detention. The early Romesh Thapar case powerfully underscored Article 32 as a guaranteed remedy, in that case for a freedom of speech violation. Second, mandamus. This means we command. It's a directive from a superior court to a public authority, a public body, maybe even an inferior court or tribunal. It compels them to perform a public duty or statutory duty that they are legally obligated to perform but have refused or failed to do so. Importantly, it generally can't be used against private individuals or non-statutory bodies.
Okay, an example for mandamus.
Sure. Let's say a passport officer unlawfully, and without giving any valid reason, refuses to issue a passport to a citizen. This affects their right to travel abroad, which the Supreme Court has read as part of Article 21, the right to life and personal liberty. The aggrieved citizen could seek a writ of mandamus to compel the officer to perform their duty and issue the passport, assuming all conditions are met. Third is prohibition. This is a preventative writ. It's issued by a superior court to stop an inferior court or tribunal from exceeding its jurisdiction or acting contrary to the rules of natural justice while a case is still pending before them. Its purpose is to halt an unlawful action before it's completed. Fourth, quo warranto. This means by what authority? This writ is used to challenge a person's legal authority to hold a public office. It's used to prevent someone from unlawfully usurping a public office or to remove someone who is holding office without the legal entitlement or qualifications.
Like if someone got a government job they weren't qualified for.
Yep. Exactly. If someone is appointed to a high public office without possessing the legally required qualifications, or maybe the appointment process violated statutory rules, a citizen could file a quo warranto petition to question the legality of that appointment. And fifth, certiorari, meaning to be certified. This writ is issued by a superior court to quash an illegal order or decision that has already been made by an inferior court or tribunal. This applies if they acted without jurisdiction or exceeded their jurisdiction, or if there's a clear error of law on the face of the record, or they violated principles of natural justice. It's a curative remedy aimed at correcting a past legal wrong.
An example for certiorari.
Okay, imagine a tribunal passes an order that negatively affects your fundamental right to carry on your business, say under Article 19(1). But it turns out the tribunal didn't have the proper jurisdiction to hear the case or followed a flawed procedure. You could then seek a writ of certiorari from a higher court to quash that illegal order.
And crucially, the Supreme Court isn't strictly tied to the old, maybe rigid technicalities of these ancient writs, is it? They have flexibility to shape the remedy.
Exactly right. The Supreme Court has consistently emphasized its wide latitude. Its primary goal under Article 32 is to ensure justice is done and fundamental rights are effectively protected. It's not bound by the archaic procedural constraints of English common law from centuries ago. It adapts these powerful tools to the modern Indian context, ensuring that the core spirit of Article 32 providing effective remedies is always upheld. This judicial creativity and flexibility has been absolutely instrumental in making fundamental rights a reality for ordinary citizens.
Okay, then there's Clause 3. which allows Parliament to empower other courts with similar writ powers.
Mhm.
And Clause 4 states this fundamental right to move the Supreme Court cannot be suspended except as the Constitution itself allows. So even in the absolute direst circumstances like a national emergency, this right to seek remedies remains incredibly strong.
That's a critical aspect of its enduring strength, yes. Parliament can, theoretically, empower high courts, which, as we mentioned, already have very wide writ powers under Article 226 or even other subordinate courts to issue these writs. Though this hasn't really happened significantly for lower courts, but critically, any such delegation wouldn't diminish or take away the Supreme Court's own original primary power under Article 32. And yes, Clause 4 is a profound safeguard. The right to move the Supreme Court under Article 32 generally cannot be suspended. The only constitutional exception is during a proclamation of emergency under Article 359. But even then, following the 44th Amendment, the enforcement of rights under Articles 20, protection regarding conviction for offenses, and Article 21, protection of life and personal liberty, cannot be suspended. This makes Article 32, especially concerning life and liberty, an incredibly robust, almost immutable right, a real bulwark against potential authoritarian overreach.
Now, here's where it gets truly captivating for me. Because the Supreme Court hasn't just kept Article 32 confined to an individual seeking justice for their own direct violation. It has dramatically expanded its reach, really democratized access to justice in a way. How did the court manage this? How did it move beyond just the directly aggrieved person?
This expansion is arguably one of the most transformative aspects of Article 32's evolution. It happened primarily through the development and embrace of public interest litigation, or PIL. The Supreme Court took a very liberal approach to interpreting the traditional concept of locus standi, basically, who has the right to bring a case before the court. Under the PIL doctrine, now any public-spirited individual or a social activist or a non-governmental organization can approach the Supreme Court, or High Court under 226, on behalf of people whose fundamental rights are being violated, but who themselves cannot approach the court.
Why might they not be able to approach the court?
Well, due to poverty, illiteracy, geographical remoteness, social vulnerability, or other disabilities, they might not have the resources, the knowledge, or the ability to navigate the legal system. PIL transformed the Supreme Court from being just a traditional arbiter of disputes between two parties into a proactive guardian of the vulnerable and often a catalyst for significant social change.
So if there's a social activist who discovers, say, a community of manual scavengers whose basic human rights under Article 17, abolition of untouchability, and 21, dignity, are being systematically violated,
Yes.
they can file a PIL on behalf of that entire community, and the Supreme Court will take up the cause. That's an extraordinary opening up of the justice system.
Absolutely. And this has led to some profoundly impactful judgments over the decades. The Bantua Mukti Morcha case in 1984 is a classic, really inspiring example. A simple letter addressed to one of the justices just describing the horrific plight of bonded laborers working in stone quarries near Delhi was treated by the court as a formal writ petition under Article 32.
Just a letter.
Just a letter. This led to extensive investigations ordered by the court and ultimately comprehensive directions for the identification, release, and rehabilitation of thousands of these laborers. It effectively enforced their fundamental rights to life and dignity under Article 21 and their right against forced labor under Article 23. Similarly, the Fertilizer Corporation Kemgar Union case in 1981 also significantly liberalized locus standi, allowing public-spirited citizens to bring actions concerning the rights of disadvantaged sections of society, even if their own rights weren't directly affected. This proactive stance has truly brought the Constitution much closer to the common person, making rights more accessible.
We've talked a lot about the Supreme Court's powers under Article 32, but how does it differ fundamentally from Article 226? That's the article giving high courts similar, maybe even broader writ powers, right? What's the key distinction?
That's a key distinction, and one that often causes a bit of confusion. The first major difference is that Article 32 is itself a fundamental right. The right to move the Supreme Court for enforcing fundamental rights is guaranteed by Part 3 of the Constitution. Article 226, on the other hand, while a vital constitutional right is not listed as a fundamental right itself, it empowers high courts to issue writs. The second big difference is the scope. Article 32 is exclusively for the enforcement of fundamental rights only.
Only fundamental rights.
Yes, whereas Article 226 allows high courts to issue writs not only for fundamental rights, but also for any other purpose. This means high courts can issue writs to enforce any other legal right, as well as statutory rights, common law rights, etc. So in that sense, the High Court's writ jurisdiction under 226 is actually broader in terms of the types of rights it can enforce.
So you could go to the High Court for more things?
Potentially, yes, for non-fundamental legal rights. And while the Supreme Court sometimes suggests approaching the High Court first under 226 for efficiency, especially if facts need investigation, Article 32 always remains a direct, guaranteed recourse to the highest court specifically for fundamental rights violations. You cannot be refused a hearing under Article 32 simply because you could have gone to the High Court. And crucially, the L. Chandrakumar case in 1997 firmly cemented that the power of judicial review under both Article 32 for the Supreme Court and Article 226 for high courts is an integral and essential feature of the Constitution. It's part of the basic structure.
Meaning it can't be taken away by legislation.
Exactly. It cannot be ousted or abridged by any legislative action, not even by a constitutional amendment that violates the basic structure. It's the ultimate check on arbitrary state power, vested in both the Supreme Court and the high courts.
So when all is said and done, what does Article 32 fundamentally mean for you, the citizen, living in a democratic nation like India?
It means you possess a direct, constitutionally guaranteed pathway straight to the highest court in the land to protect your most cherished, most fundamental rights. It's the crucial mechanism that makes every other fundamental right real, tangible, and most importantly, enforceable. Without this provision, those freedoms could remain abstract ideals, just words on paper. Article 32 gives them teeth. It ensures they're not just theoretical declarations, but living, breathing protections that can be actively sought and enforced, even against the most powerful entities, including the state itself. It's truly the ultimate guardian of our liberties.
Okay, finally, let's just briefly touch upon Article 33. This seems to be almost the flip side, allowing Parliament to actually modify or restrict fundamental rights in certain specific contexts. Which groups does this apply to, and what's the thinking behind it?
Indeed, Article 33 represents a pragmatic acknowledgement by the Constitution framers of certain unique operational realities for specific arms of the state. It specifically empowers Parliament only, Parliament, not state legislatures, to modify or even restrict the application of fundamental rights when it comes to members of certain groups. These groups are clearly listed: members of the armed forces, forces charged with the maintenance of public order like the police, personnel employed in intelligence or counterintelligence agencies, and also those employed in telecommunication systems set up for these forces.
So defense, police, intelligence.
Right. The rationale is quite straightforward and, well, practical. It's done to ensure the proper discharge of their duties and, crucially, the maintenance of discipline within these specialized, often hierarchical and sensitive organizations. In these specific contexts, the state needs the ability to balance individual liberties, like freedom of speech or association, with paramount concerns of national security, public order, secrecy, and the overall effective functioning of its defense and law enforcement machinery. It's a carefully crafted exception limited to these specific groups and enacted only by Parliament for a very specific functional purpose. #outro.
Wow. What an absolutely incredible journey we've taken today. Really covered a lot of ground. From meticulously protecting that intricate tapestry of India's cultures and educational choices through Articles 29 and 30, to examining the state's really powerful tools for sweeping socioeconomic transformation in Articles 31A, 31B, and 31C. And finally, diving deep into that foundational guarantee of remedies, the safety net embodied in Article 32. We've truly seen the incredible depths, the dynamism, and the complexity of the Indian Constitution.
We really have.
It's so much more than just a legal document, isn't it? It feels like a living, breathing saga of a nation's aspirations, its challenges, its ongoing negotiations.
Absolutely. And if we try to connect all these threads, look at the bigger picture, what powerfully stands out, I think, is that constant, delicate, and often quite contentious balancing act. It's right there at the heart of India's constitutional governance. It's this continuous negotiation. Individual rights versus the collective good, the assertion of state power for reform versus the absolute necessity of protecting citizens, and underpinning it all, the dynamic, indispensable role of judicial review in maintaining this fundamental constitutional equilibrium.
They're not static words.
Not at all. These articles are anything but static. They represent living principles, constantly being interpreted, debated, applied in new contexts. They profoundly reflect India's ongoing journey as a democratic, incredibly diverse and developing nation, always striving, sometimes struggling, for justice and equality amidst immense complexity.
So, thinking about all this, what does it really mean for you, the informed citizen listening to this? Understanding these constitutional pillars, it's clearly not just an academic exercise. It reveals the intricate, often quite brilliant, design that aims to safeguard freedoms while simultaneously driving necessary progress. Just consider how this intricate web of rights, safeguards, state powers, judicial oversight, legislative intent, how it constantly evolves, how it shapes the very definition of what we consider a just and equitable society. How does knowing this framework empower you, perhaps, to engage more deeply with the principles that govern your nation, or really any democratic nation? It's a testament to the power of a written constitution, but maybe also a reminder of the continuous effort needed from everyone to uphold its ideals.
It really does raise an important question for all of us, doesn't it? In today's world, saturated with information where headlines often grab our attention but rarely give us the deep context, how crucial is it to actually delve deeper, to truly understand these bedrock principles that protect our diverse identities, that enable societal progress, and that ultimately provide the mechanisms to ensure justice for all? It's an ongoing conversation, this constitutional journey, and one we really hope you'll continue to explore long after this deep dive ends.